Welcome to the next in our series of podcasts. My name is Tom Ince, a partner and Deputy Practice Group Leader in the employment team in London, and today we're going to be giving you an overview of how to conduct a disciplinary process. It's very likely that a manager would have to conduct a disciplinary process at some stage in their career. A fair procedure is very important, otherwise any resulting dismissal is likely to be unfair. Managers should be familiar with the principles set out in the ACAS Code of Practice on disciplinary and grievance procedures. This podcast considers misconduct issues rather than poor performance or sickness issues. It gives an overview rather than detailed guidance. So let's look at the legal background. It's worth noting that for a dismissal to be fair, the employer must have a fair reason for dismissal. Misconduct is a potentially fair reason for dismissal. The employer must act reasonably in treating that reason as sufficient to justify dismissal. That includes following a fair procedure. The dismissal must be fair and reasonable in all the circumstances. Tribunals will consider any breach of the ACAS code in assessing whether an employer acted reasonably. Compensation can be adjusted upwards by up to 25% if an employer unreasonably fails to comply with the ACAS code. So let's look at the procedure. What procedure should an employer follow? Let's say something has happened. Firstly, consider whether any formal action is necessary. Would a quiet word be enough? And this really depends on how serious it is. If you decide to take informal action, it probably should be verbal only and not put on the disciplinary record, although a manager should keep a note of it. Secondly, consider whether any investigation is needed. What's required will vary greatly depending on the circumstances. You need to make sure that the facts are established so that a clear case can be put to the employee. Usually, the person who does the investigation should not be the disciplinary decision maker. The employer must undertake such investigation as is reasonable in all the circumstances. You need to be able to put the substance of the allegations to the employee so that the employee can give a meaningful response. Thirdly, consider whether the employee should be suspended. A knee-jerk reaction to suspend could lead to a claim for breach of trust and confidence, and this could be an expensive claim. Careful thought needs to be given before a decision to suspend. Suspension is only really appropriate if there is a potential threat to the business or other employees, or if it is not possible to investigate properly if the employee stays at work. Suspension should be on full pay, and it's obviously safer if the employment contract provides for the right of suspension. Keep the suspension under review and for as short a time as possible. Next, obtain all the evidence. Conduct the investigation as quickly as possible. Speak to the witnesses. When interviewing the witnesses, they should be advised to keep the matter confidential. Consider if you need any physical evidence, for example emails, CCTV and phone records, although you'll need to comply with the relevant legal provisions in respect of those, which is outside the content of this podcast. Keep the investigation reasonable and proportionate. Don't go on a fishing expedition. Once the evidence is obtained, invite the employee to a disciplinary hearing. That invitation should be in writing. Set out clearly all of the allegations and evidence against the employee and give them copies of the evidence. Set out the possible consequences for the employee, for example that it may lead to dismissal. The hearing should be at a reasonable time and place. Give the employee sufficient time to consider the allegations before the hearing. They must know the case against them. But be careful how you frame the charges against the employee. An employee should only be dismissed for the charges put to them and not different charges. The next step is obviously to hold the hearing. If the employee fails to attend, you should usually rearrange the meeting. But if the employee persistently fails to attend without good reason, there will come a point in time when you need to consider taking the decision in their absence. Often employees will go off sick, which may lead to complications which need to be handled carefully. That is outside the remit of this podcast. Keep a note of the hearing and allow the employee to be accompanied to the hearing by a fellow employee or a trade union official. You cannot deny an employee their choice of companion if they are a fellow employee or trade union official. At the hearing, go through the allegations and evidence and allow the employee the opportunity to make full representations about the points. Once this has happened, adjourn the hearing for any further investigation or to make your decision. Once you've adjourned, make and issue your decision. You'll need to consider all the evidence and the representations that have been made by the employee, and you will need to weigh up any conflicting evidence. For a dismissal, an employer must have a genuine belief based on reasonable grounds that the employee is guilty of misconduct. Any decision to dismiss must be fair and reasonable in all the circumstances. The tribunal will consider whether a dismissal was in the band of reasonable responses for an employer, and you should therefore consider whether a warning is more appropriate than dismissal, although warnings themselves also come with legal risk. You should issue the decision without delay. Ideally, you would reconvene the meeting to inform the employee of the decision, but you should always issue the decision in writing. The final step is to hear any appeal. The employee should be given the opportunity to appeal, to set out their grounds of appeal in writing. You would then hold an appeal meeting, which should usually be heard by a more senior manager. Following the appeal hearing, the appeal decision should be issued, and that should be the final step in the process. So this podcast has given you an overview of how to conduct a disciplinary hearing. In the upcoming series of podcasts, we'll go into more detailed issues. As always, the London Labour and Employment Group is available to answer your questions. Please find contact details of the group embedded onto the webpage that led you to this link. Thank you.